My name is Frank Ally. I'm a California attorney primarily focusing on family law issues. Now let's get started. Hi, my name is Frank Ally, and we're continuing our discussions with this episode involving community and separate property. I'm going to today use a topic called transmutations. A great word. What does it mean? We've talked in prior videos that property can be classified as community property earned or acquired during the marriage. It's separate property, premarital property, or other things previously defined, or mixed property, when community property and separate property are mixed together. And we have to kind of figure out later on how to divide up or trace the community and separate property interest. But sometimes during the marriage, you can do something called a transmutation. Sounds fancy, but what a transmutation is when you change the characterization of a property. For example, I own a house. It is my separate property. And during the course of the marriage, for whatever reason, I decide I would like to change that separate property to be a community asset. Now there's requirements for a transmutation to occur. And you need to consult with an attorney because there's a series of cases of what constitutes a transmutation and what doesn't. But for today's purposes and limited purposes for this particular episode, a transmutation is simply when you change property from community property to separate property or separate property to community property. The only thing you need to be careful on transmutations is this. We talked about fiduciary duties in prior videos. And a fiduciary duty means that you need to put the interest of your spouse above your own personal interest, or actually you need to put the interest of the community above your own personal interest. So if suddenly your spouse transmutes a separate piece of property to the community or over to you, the court's going to take a look at this and say, was this transaction done in good faith? Was it fair dealing? And was proper consideration paid for that change? And there's two cases involved. There's a lot of cases, but there's two main cases. One is the Haynes case and one is the Delaney case. In the Delaney case, the court found that the transfer of a property from separate property of one party to a community asset was a result of undue influence of the spouse who had it transferred into their particular name. There's a presumption that when a transaction on its surface is not fair to one party, there's a presumption that that transaction was as a result of undue influence. That presumption is a violation of fiduciary duty, and that transaction or transmutation will be overturned by the courts as if it never happened. So we can talk more about that in future episodes, or if you have any questions, please put the comments below and we'll answer them. But for purposes now, it's important to understand that you can transmute property, but you need to be very careful and it needs to be fair. I'm Frank Ally, California family law attorney. Hope this was helpful.